Good morning. This is the podcast, Ancient Rome Today. In the previous episode, we discussed some Roman laws and that they were not always in favor of ordinary people. In fact, the primary purpose of the legislative system in ancient Rome was to maintain order and guarantee rights to people according to their social status. Roman laws also established the rules for many political, social, and international processes. So today we will talk about the most important Roman laws in history to understand how they became the foundation for many legislative systems in modern countries. The Roman law is based on a complex legal system, which had been in continuous development from the foundation of Rome until 568 AD. The first phase, known as archaic law, began in 753 BC and lasted until 451 BC. During this period, private law, including Roman civil law, was applied only to Roman citizens. It was also closely tied to the prevailing religion of the time. It was an undeveloped legal form, therefore not containing the attributes of rigorous formalism, symbolism, and conservatism. The beginning of the second period coincides with the laws of the 12 tables written on bronze tablets. This transition to the written form of law was an important step, as it had previously existed only in oral form, which had favored magistrates in applying it arbitrarily. The third period of Roman law development coincides with the end of the Second Punic War and lasts until the establishment of the empire. That period is known as pre-classical and is associated with the production of a large number of treatises by jurists. Among the most famous jurists of that period are Quintus Mucius Scaevola, an author of a voluminous treatise on all aspects of Roman law, and Servius Sulpicius Rufus, a friend of Marcus Tullius Cicero. The first 250 years of the empire, from 27 BC to the death of Emperor Alexander Severus in 235 AD, correspond to the so-called classical period. This historical moment marks the highest point of Roman law and jurisprudence. Roman jurists clearly distinguished between the use of a thing, property in legal law, and the possibility of using and manipulating that thing, possession. Standard contracts of sale, work, lease, service contract were regulated in the most important continental codes. The characteristics of these contracts were developed in Roman jurisprudence. The last period in the development of Roman law is the so-called post-classical period, from the death of Alexander Severus to 565 AD. During this period, the conditions for legal culture became less favorable than before, since the general political and economic situation deteriorated. Today, Roman law is no longer applied in modern jurisprudence. However, in the legal systems of some states, such as South Africa and San Marino, some parts are still based on the ius commune. However, even if the case law is based on a code, many rules are derived from Roman law. No code has completely broken ties with the Roman jurisprudence. Instead, the provisions of Roman law have been tailored into a more coherent system, expressed in the national language of many states. As a fundamental step towards the unification of private law in the member states of the European Union, the old jus commune was adopted, which served as the common basis of legal practice throughout the world, later allowing for many local variations, and is regarded by many as a basic model. Thank you for your attention.